everybody. My name is James McHugh and I am part of the employment team here in Trinity Chambers. What I'm going to be talking to you about today is the childcare disparity in indirect sex discrimination claims, and specifically two Employment Appeal Tribunal authorities which deal with the question of the childcare disparity and how tribunals should or shouldn't be taking it into account alongside other evidence. To begin with, as most employment lawyers are familiar with, the basic concept of indirect discrimination and the duties that are imposed on us by Section 19 of the Equality Act. But to recap, the basic premise is that a person is prohibited from applying to another person a provision, criterion, or practice which is discriminatory in relation to that person's relevant protected characteristic. A PCP is deemed to be discriminatory if it either applies or would apply to persons with whom B does not share the protected characteristic, puts or would put persons with whom B shares the characteristic at a particular disadvantage when compared with persons with whom they do not share the protected characteristic. It actually puts that person at the disadvantage, and it cannot be shown to be a proportionate means of achieving a legitimate aim. There have been a number of appellate authorities dealing with the issue of childcare specifically in relation to indirect sex discrimination, and in particular dealing with the level of judicial notice that can be given to the fact that, as a general proposition, the burden of dealing with childcare falls disproportionately on female members of society as opposed to male members of society. The two cases that I'm going to discuss in more detail are firstly Dobson and North Cumbria Integrated Care NHS Foundation Trust, which is a 2021 EAT decision, and secondly, Cowie versus the Scottish Fire and Rescue Service, which is a 2022 EAT decision. Starting with Dobson, the basic facts in Dobson were these. The claimant was a community care nurse with 3 children, 2 of whom were disabled, and she was employed by the respondent Foundation NHS Trust. Her working arrangement originally required her to work 2 fixed days per week as part of a team of 10 community nurses. The respondent undertook a review of its working practices and proposed new contract terms to its community nurses, which included a requirement to work flexibly, including the occasional weekend. The claimant informed the respondent that she would be unable to agree to these new terms due to her caring responsibilities for her children. The claimant ultimately rejected the new terms proposed by the Respondent Foundation Trust and was dismissed as a result. Following dismissal, the claimant brought a number of claims to the Employment Tribunal, including one of indirect sex discrimination. Following a first hearing, the Employment Tribunal made the following findings which were relevant to the Section 19 Equality Act claim. There were, of course, other findings made, but as this talk focuses on indirect discrimination, I'm going to stay focused on the indirect sex discrimination findings. So the first of those findings was that the PCP that had been applied was the respondent requiring its employees to work flexibly, including at the weekend. Secondly, it made a finding that no evidence had been adduced that women as a group were disadvantaged as compared to their male counterparts. Thirdly, it found that there was evidence that the claimant was disadvantaged personally, but that none of the other members of her teams were. And fourthly, that in any event, the new terms were justified as a proportionate means of achieving the legitimate aim of providing a safe and effective service. The interesting part of the appeal on Dobson for our basis relates to the childcare disparity and specifically when judicial notice can or can't be taken of the childcare disparity. The following key principles can be distilled from the judgment of the EAT. Firstly, the EAT said tribunals ought to take into account the fact that women bear the greater burden of childcare responsibilities than men, and that this can limit their ability to work certain hours. And that is a matter in which judicial notice has been taken without further inquiry on several occasions. The second key finding is that the childcare disparity falls into the category of matters that a tribunal must take into account if it is relevant to the claim. Thirdly, taking judicial notice of the childcare disparity does not necessarily mean that group disadvantage is made out. Whether or not the disadvantage is made out will depend on the interrelationship between the general position that is the result of the childcare disparity and the particular provision, criterion or practice in question in the case. Fourthly, the evidence of individual disadvantage is important, although importantly not conclusive, when assessing whether group disadvantage is made out. And fifthly, the EAT gave general guidance and general factors which a tribunal ought to take into account when considering group disadvantage in a claim of indirect sex discrimination. And the factors that the EAT said all tribunals should be taking into account when determining indirect sex discrimination claims in relation to childcare and indirect sex discrimination claims more widely are these. Firstly, there may be statistical or other tangible evidence of disadvantage, but the absence of those should not usually result in a claim being dismissed. Group disadvantage may be inferred from the fact that there is a particular disadvantage in the individual case, although this will depend on the facts of each case. Thirdly, the disadvantage may be inherent in the PCP in question and that the tribunal can determine it as a matter of logic. And lastly, that disadvantage may be established having regard to matters such as the childcare disparity of which judicial notice should be taken. Again, this is something that the EAT emphasised will depend on the individual circumstances of each case. Moving on to deal with the case of Cowie and the Scottish Fire and Rescue Service. This, again setting out the facts, was a claim in which the respondent fire service operated a special leave policy as part of its commitment to assist employees in balancing their work-life responsibilities. The respondent fire service also operated a policy of time off in lieu or toil, which could be accrued through overtime and extra duties. During the coronavirus pandemic, employees unable to work their full contractual hours and those who had to shield and could not work from home could apply for paid special leave, but as a requirement to access the paid special leave were required to exhaust any existing accrued toil or annual leave first before they could access the special leave. This resulted in Cowie in a group of female employees bringing a claim of indirect sex discrimination, alleging that the disruption in childcare arrangements brought on by the COVID pandemic meant that they were more likely to need to take time off than their male counterparts, and that as a result, their requirement to exhaust their toil or annual leave before accessing special leave placed them at a disadvantage compared to those who didn't share their protected characteristic. The claim resulted in a 5-day hearing taking place remotely at the Glasgow Employment Tribunal, and at first instance, the Section 19 claim was dismissed. In dismissing the first instance claim, the tribunal made the following relevant findings. Firstly, that the respondent did indeed apply a PCP of requiring employees to take annual leave and/or toil before being granted special leave in the context of COVID-19. Secondly, that the PCP applied equally to male and female staff. Thirdly, that requiring the claimants to use their accrued toil and requiring the claimants to use their annual leave when they didn't wish to do so did in principle amount to a disadvantage. Fourthly, that there was insufficient evidence to establish a general disadvantage caused to female employees by the PCP in comparison to their male counterparts. Fifthly, that if there had been a general disadvantage, the individual claimants in the group claim were subjected to that disadvantage. And finally, that if the claimants had been successful in relation to disadvantage, the respondent could not justify the same as a proportionate means of achieving a legitimate aim. The unsuccessful claimants appealed to the Employment Appeal Tribunal, and that appeal was heard by the then president of the EAT, Lady Edie. On appeal, the claimants argued the following. Firstly, that it wasn't controversial that the COVID-19 pandemic created, via the closure of school and nurseries or the disruption to informal childcare arrangements, an additional childcare burden on a significant number of families across the UK. Secondly, that the increased childcare burden caused by the COVID-19 pandemic is and was more likely to fall disproportionately on female employees than their male counterparts, i.e., the childcare disparity. Thirdly, that due to that increased childcare burden, the respondents' female employees were more likely to need to access the special leave policy than the respondents' male employees, and therefore more likely to be required to exhaust their accrued toil or annual leave, placing them at a disadvantage when compared to their male counterparts. And lastly, that in finding that the individual employees were placed at the alleged disadvantage caused by the PCP, this should have been given more weight by the EAT when considering the question of whether group disadvantage was made out. Unusually, the EAT rejected the claimant's appeal and found that the Employment Tribunal had not fallen foul of the general guidance provided in the earlier decision of Dobson. This is notwithstanding the fact that the childcare disparity as a general proposition would have caused the female employees to face more childcare burden than their male counterparts. What the EAT found in Cowie was that whilst they had a great deal of sympathy for the claimants in the group Section 19 claim, that the ET, the Employment Tribunal at first instance, had carried out a careful analysis of the evidence before it, and whilst acknowledging the impact of the childcare disparity generally, it had correctly found that in the unique circumstances caused by the COVID-19 pandemic, it would not be safe to assume any group disadvantage in the absence of evidence generally. And so, to summarise, what are the lessons that we can take from these two cases? Well, firstly, it's made abundantly clear, if it wasn't already, that the childcare disparity is something that employment tribunals should be taking judicial notice of as a matter of course. As soon as it is raised, and without it being needed to heard in evidence orally, in live evidence at the tribunal, it falls within the manner of things that a tribunal should be taking judicial notice of regularly. However, the second and perhaps more important lesson is that despite the fact that tribunals ought to take into account the childcare disparity and its very real existence, on its own, it will often not be enough to get a Section 19 claim relying on group disadvantage caused by childcare responsibilities over the line. Individuals who are bringing claims relying on the childcare disparity need to carefully think about the evidence that they need to adduce as to how the PCP and the individual PCP in question in each case places them at a disadvantage compared to those who don't share their protected characteristic, and how they are going to evidence that in tribunal. My advice more generally, if you're planning on bringing a Section 19 claim, or you have clients who are bringing a Section 19 claim relying on the childcare disparity, is that whilst tribunals will need to take judicial notice of this, further evidence should be carefully considered to support any claim in addition to the accepted notion of the childcare disparity. it may be a risky strategy to rely on the childcare disparity alone. And as I've already emphasised, careful consideration needs to be given to what additional evidence can be adduced in order to support reliance of group disadvantage in relation to the individual PCP that appears to offend the Equality Act. Thank you very much for listening, and if you have any queries arising from the topic of this talk, feel free to contact either me individually or Chambers directly. Thanks a lot.